Thank you. Lord ALTON.
Yeah, thank you. Professor Sampson, the last time we met was discussing the proposal to abolish your office. And I think it would be interesting for the committee, at least in parenthesis, to know why they thought it was a credible proposition to abolish the office and how you convinced them to retain it. If I can then as well ask you something very specific. You referred earlier on to Article 8 of the European Convention on Human Rights, and specifically the safeguarding of information that might affect an individual or a family's right to privacy. I think back in 2022 your role as Surveillance Camera Commissioner was merged with this role of Biometrics Commissioner. I wonder if you can tell us how effective you think that the Surveillance Camera Code is in protecting those rights, and whether you think the penalties are sufficient as well when those rights are not observed.
Okay, so the first one again is very straightforward in terms of how I've managed. I haven't managed to persuade the Home Office of this or little else actually, but I certainly haven't managed them to persuade them to abandon scrapping the code, which then means you don't need a surveillance camera commissioner. It's simply that the legislative process is taking rather longer, perhaps than had been planned, and certainly longer than my appointment. So the plan within the Data Protection and Digital Information Act is to delete the requirement to publish a surveillance camera code by the government, and therefore you don't need half of me, and that still obtains. That is on its way through Parliament. So I agree to be reappointed while that carries on the legislative journey, but the policy intent remains fixed. In terms of the policy intent itself, policy is a matter for others, and my job is to oversee compliance with the code and to advise on it, which I do. The code was, as you'll know better than I here, was required by Parliament in 2012 as an additional layer to general information and data protection controls, given that the people using it were police and local authorities and with investigative functions. So it was seen as an additional layer that was needed given the consequences. At the time that the code was introduced, Edward Snowden was still a trusted contractor for the NSA. And I've yet to see anything that's happened over the subsequent 10 years that's indicated we need less regulation around state surveillance in public spaces or anywhere else. We probably need better regulation, but in fact scrapping the code will mean that it's the single instrument that directly regulates the police and local authority use of public space surveillance, and it will go. In terms of the effectiveness of the code, I think it's a very good instrument. I think it's incomplete. I tried to get a small sentence inserted last year that said, and by the way, do it ethically, and that wasn't to be done. But it does regulate in some great detail how surveillance operators should use their systems responsibly and in a way that the public would rightly expect and in a way that retains their trust and confidence. And I know that because that was a paragraph I did manage to get it. But applying it only to the police and local authorities it doesn't make a lot of sense to me, but I think there is a clear alternative, and I put this in my public response to the consultation to say, well, an alternative would be for government to adopt that code themselves across the government estate, for example, which has caused some concern in the past. And I increasingly have retailers asking if they can adopt it and for advice on how they would adopt it, because it makes a great deal of business sense for them to do so. And it goes through everything from training, standards of the equipment, who you can share it with, minimum levels of intrusion. It reinforces the articles that are relevant from the convention, and it underpins the general data protection principles. So it's an instrument that works. It hasn't been challenged successfully or at all, I don't think, in the courts, and it's a government instrument and people have got used to it. So, but there are no penalties for failing to follow it, but it can be and will be taken into account by a court in the event that it was relevant in proceedings, and it was in Bridges actually.
And Article 8?
And Article 8, it covers off some of the areas in terms of, what we might loosely call privacy considerations. But I think it needs to go further if it was to stay around. But of course, part of the difficulty I've now got is knowing that it is, it's on death row. The code, it is simply waiting for, and subject to the will of Parliament, that it will be gone and we won't have one. So I can't put a great deal more effort in through the team to say, how we might adjust it or tweak it.
Chair, if I can just pursue that for a moment, finally. The Information Commissioner, John Edwards, this week spoke out about the tragic case of Nicola Bulley in Lancashire and said that data protection law exists to ensure people's personal information is used properly and fairly. And he said that he'd now asked the Lancashire Police to review their decision about some of the information that has been disclosed and has caused such distress to Nicola's family. And I wonder if you link with other commissioners like him in making sure that we have effective responses in cases like that.
We do work with the Information Commissioner's Office. We have regular update meetings. I think at the moment the ICO's position has been we have this covered in terms of surveillance cameras for public space, and therefore any guidance that they produce doesn't duplicate anything that we might do. I think one of the areas for me in relation to data protection is that there are matters arising from surveillance practices that aren't covered by general data protection regulations. A clear example for me would be the offending of double murderer David Fuller, who, as well as committing 2 murders, sexually abused, they estimate, over 100 corpses in mortuaries, filmed himself doing so, and retained the footage. Had he conducted a data protection impact assessment before making those hideous films, data protection isn't engaged because it only protects the rights of the living, irrespective of the distress that it might cause to relatives. The same will be true of the police officers who were properly, in my view, sacked for taking pictures of murder victims and sharing them. In terms of data protection, again, you're back to an identified living person. What that means in terms of the future and our increasing capability for surveillance, I don't know. And again, policy is for others. But it isn't all covered by data protection.
Thank you very much. Thank you, Chair.
Very interesting. Helena, did you want to come in with a supplementary?